Now, this RFE will show you exactly what you shouldn't do in a change in work location. So this was a client who came to us after, the RFE was, the H1 was filed on their own, and they came to us and they got the RFE. And this is a learning moment as to, what not to do, whether you're a beneficiary or whether you're an employer, what you shouldn't do. And you can see what happens. So in this particular case, just to give you some background, um, the petition was filed for this beneficiary in 2021. And when this petition was filed, the USCIS noticed that the LCA location was Alabama, but the pay stubs and the work location seemed to be North Carolina because all the taxes were being filed from North Carolina, the pay stubs, his address was given as North Carolina in the I-129 petition. So they immediately sent an RFE in 2021 stating that, it seems like you are not working at the location that you're supposed to be working at. This, I guess, in 2021 was an extension was filed at that time, or an amendment was filed, whatever it was. They said that you previously you didn't seem like you were working where you're supposed to be working. So they sent a big RFE asking for W-2s, etc., etc. So what had happened at that time is that the employer basically did not notice that the address had changed. So the person was working from the correct address. He was working from Alabama, but the employer forgot to change that in their taxes. So they continued to pay taxes for North Carolina. They continued to use his North Carolina, which was his old address, while paying his taxes, etc., etc. Everything was North Carolina, even though physically he was located in Alabama. So this was more a tax violation. They didn't actually violate immigration law. So it was important to show that the physical location was Alabama as per the LCA, but it was just a tax violation, uh, a, a tax problem. So unfortunately, the attorney at that time did not show that, did not highlight that, and therefore this case was denied. And the second mistake that the employer made was after the H1 was denied, the beneficiary continued working on his old H1 as if nothing had happened. So that was an issue as well. So that issue is also raised in this RFE. And then the third issue is when they filed this present case, what had happened is the person started working in Colorado, but they filed the petition after he moved to Colorado. They should have filed the petition before. So they brought that up also as an issue. So let's go through the RFE. It says your petition was filed with a subsequent request to extend the beneficiary's stay. To qualify for an extension, the beneficiary must show that they're maintaining status. And then they talk about how the previous petition was filed on May 5th, 2021. And they say on May 2022, you filed a petition with receipt number to amend the previously approved petition. And then in 2022, they sent an RFE. And then it states that, Birmingham, Alabama was provided as the LCA information, but the address was mentioned as North Carolina. And then it goes on to say that furthermore, the previously filed petition and the current address, you have provided a copy of the beneficiary's 2021 W-2 from your organization. This W-2 does not show any wages paid to the beneficiary for work performed in the state of Alabama. Instead, it shows that the organization only employed the beneficiary in the state of North Carolina. This is the last paragraph. So this is what they're saying is what I just explained. Next page. Furthermore, they say you've provided a copy of the beneficiary's 2022 W-2 forms, and even this has work performed in North Carolina, and you show that the 2022 forms also have work performed in Colorado. However, you never submitted a USCIS request requesting approval for beneficiary to work in North Carolina because the person was not actually working in North Carolina, he was working in Alabama. But the taxes all show that he's working in North Carolina, right? So they say that they denied the petition in 2022. They denied your request to extend the beneficiary status. You were informed that since you did not file a petition to reflect a change in beneficiary's employment, the beneficiary has not maintained their previously approved H1 status. And it says that at this time you are further informed that the decision may leave the beneficiary without any lawful status, etc., etc. So now they're at the time of the denial, the beneficiary was required to obtain a valid visa and leave the country and come back into the United States. So that's what they're saying, but they're saying that the records don't show that anybody has left. The record shows that the person is still in the US. So they want to know what's happening, on what basis they've been working since 2022. This is now 2024. Therefore, it appears the last paragraph, the beneficiary has not maintained their non-immigrant status as explained in detail above, right? This is all that they're saying. Next page. So now they're asking for all this information, detailed explanation regarding change in work location, copy of the approval to show that that new work location was actually approved by USCIS, any receipt numbers for the petitions that you might have filed asking for a change in work location, all your payroll documents, work schedules for the prior years, quarterly wage statement showing where the person worked, the federal tax returns, work product information, performance reviews, everything. They're asking for employment history records, copies of a valid visa to show that you left and re-entered the country. They're asking for all this information, and of course they have nothing, or even if they have any of the documents, it's not going to be in their favor because there was a mistake, and they just continued working on the previous H1 instead of leaving and coming back, after filing a new H1 and correcting all the mistakes. So based on all this, what we did was we tried to respond in the best way we could. We showed them that with reference to the address issue, that even though they say North Carolina in all the taxes, the person actually did work out of Alabama, and we showed proof of physical presence in Alabama. We showed his copy of his lease. We showed all his utility bills. We showed his credit card statements, his bank records to show that he actually was living in Alabama, right? So that's how we sought to take care of that issue. With reference to the fact that he never left the country after getting a denial, we said that he worked based on his previous H-1B petition because the previous H-1B petition was never revoked. So he did not actually have to leave the country. And we argued it that way, that he had previously an I-94 and he worked based on that. So at least there's no accruance of unlawful presence, which is important. There was an I-94. Even though he's not maintained status technically because they never actually explained the fact that he worked physically in the correct location, so he didn't maintain status. But there's no unlawful presence because there's an I-94, so that was important to show them. And the third thing with reference to Colorado is we said that, yes, he did move before the USCIS petition was filed, but it was only 30 days since he moved. And that's how, and there's an exception with reference to the law that you can move within 30 days of, and then you can file an amendment 30 days later. Having said all that, they did send a denial, and though they accepted a few things that we have said, on the whole, obviously the beneficiary did not maintain status, did not explain properly with reference to what had actually happened, and by the time we explained, it was too late. So they denied the entire petition, and now the beneficiary left the country and is hoping to refile. And we're hoping there's no unlawful presence issue here because there was an I-94 based on which he worked, even though he shouldn't have, because after that he moved to different locations and he still worked on the previous, LCA petition. So that's how we dealt with it. And you can see the mess that it's created. And we were not able to correct the mess that happened 2 years ago. And, the person had to basically leave. So this is an example of what not to do. Don't forget to subscribe to our videos if you like what you see. Also give us a thumbs up and share the video with your family and friends. Thank you.